What finally happened with the TikTok ban off the United States Supreme Court decision that declared effectively it wasn't a First Amendment issue at all, it was a national security issue, having declared that China was a foreign adversary that controlled the application? What did the United States Supreme Court do, and what are Donald Trump's next moves as a result? First Amendment versus national security. Dina Sayegh-Dahl versus Michael Popak, only on Unprecedented, every week, right here on Legal AF. Take a moment, hit the free subscribe button, and here's a clip to whet your appetite of a Unprecedented After Dark edition. Take a listen.
And just to recap really fast on the TikTok thing, because we haven't had the show since the decision, I was always against that law because I felt like it was a violation of the First Amendment. But as you said, they found it to not. And I saw so much commentary in mainstream media, so much commentary that the government was worried about the influence on the American people with the content of the app, and they could have propaganda through this TikTok. The Supreme Court did not base their decision on that whatsoever.
National security.
That's the more disturbing part to me.
Yeah.
They allow the government to have a divestiture, which was, or a ban, however you want to look at it. But they worded the law in such a way that the Supreme Court kind of decided not to look at the reality of it and just look at the words of it, and said that this was content neutral. It was not a content-based law, and the law had nothing to do with content, but only data security, even though the government had no evidence, issued no evidence of any, of the parent company giving the Chinese government any data.
They don't have to. That's where you and I always have our debate. Yeah. Once Congress designated TikTok to be a foreign adversary controlled app, it's right there in the name. Mm-hmm. That then the question for the Supreme Court was, if you have a foreign, and Congress is giving wide latitude to determine its own national security interest for the United States, right? Just as the president is the commander in chief, can make treaties. Congress determines our national safety. They made a decision, which is not going to be disturbed easily or at all by a Supreme Court, that this was a foreign adversary, emphasis on adversary, controlled application. That's how it was referred to over and over again in the order, in the decision, on purpose. Once they made that decision, Congress, Supreme Court is saying, once they make the national security balance, they make the balance, not us. We are not going to overturn that balance. And there are just times when the First Amendment is going to take a back seat to national security policy implemented by Congress. That's how they wrote the decision. And they even to demonstrate that, once they lowered the judicial scrutiny level from strict scrutiny to intermediate scrutiny, meaning strict scrutiny, it's almost impossible for any regulation of First Amendment speech to pass strict scrutiny, because you'd have to show so many things in order for that government's law to survive. Once they dropped it down to intermediate scrutiny, which is what they did, this thing was going to pass. Well, so that's how it did it. Yeah. They said national security is the province of Congress.
I thought that it was kind of a joke, though, that this wasn't about content. All the Congress people at the time of the law were talking about it being about content. I think this was clearly about content. There's Temu taking data all the time. But I
don't think it's content. I'll tell you why.
Well, but let me so I think, though, that I would have thought that I think that they should have said it was a content-based law. And then it might have still applied strict scrutiny because you have China as a foreign adversary. But for them to take away the freedom of speech and the freedom to listen, we do have a freedom to receive information in this country too, without even saying this had anything to do with content. I thought it was so disingenuous. Justice Gorsuch in his dissent basically said that as well, which I agreed with him there. And he also pointed out that they decided this major First Amendment case in 1 week. It was too short a time. And I think that so that I would have been at least acknowledge this was about content. And then you can decide whether or not the national security interest meets the strict scrutiny, and it very well might have.
Yeah, point, counterpoint. See, I don't see it that way. Yeah. Not because I'm against TikTok. And the way I'm going to describe it, you're going to know that I'm not against TikTok. It wasn't content-based because they don't care about the video. They care about the back end where the Chinese government has a right in every company, whenever you and I talk about Chinese companies on this channel or on this network, whether it's DeepSeek, this new AI thing, the Chinese, when you hear Chinese startup, you hear Chinese new company, they have, in order to operate, because it's not a capitalist system, it's a communist system, they have to agree that they'll allow their servers effectively to be pulled on a moment's notice by the Chinese government, and all of that data dumped into China's military industrial complex for whatever Chinese government's purpose is, and you can't say a darn thing about it, or you're going to be shut down and put in jail. It's not the videos; it's the information and data that is accumulated so huge in terms of the 170 million just U.S. citizens, let alone everybody else, that it would take artificial intelligence to make its way through it. But that data dump, they don't have to prove the data dump. They just have to prove that it is a possibility that this data information, not the videos, the stuff that's generated from the back end could end up in foreign adversary hands that could be used against us is enough. And that's all that it's a Trojan horse. That's their argument. You may not agree with it, but it's not it's not the video that you do or the dance craze or the criticisms or anything else. I know tons of Midas contributors that are on TikTok. Adam Mockler is there. You're there. The list goes on. There's tons, the Midas Touch people we're all there. What are you doing right now, by the way? Like, where are you now?
Oh, I'm still on TikTok. Yeah.
See?
Yeah. No, but here's the thing. Yeah, but people who deleted the app can't get it back. So, okay, here's the thing is, when we sometimes have to interpret a contract, you look at the statements the parties made at the time of the contract to try to get the intent if it's not clear in the contract. Congress talked over and over about the influence of the content from China. They were worried about it. At oral arguments, they talked about China wanting to make Americans fight. In their pleading, they talked about the criticism of the leaders of our country. So for the Supreme Court to ignore, and I think that's what they did, ignore that the clear purpose and intent is they did not want China influencing how Americans think, to me was wrong. Yeah. That's where I'll put it. And the national security agreement about the American data that they had with Oracle to try to safeguard it. I'm okay if the Supreme Court had said, you know what? I hear you're worried about the influence of propaganda from China. I hear you're worried about by the Chinese data, but this is a free speech issue that we need to apply strict scrutiny, and it could have overcome it. That was my takeaway on that is,
the TikTok lawyer was dead on arrival when they said to him, guarantee for us that the information on the back end of TikTok is not going to end up in the hands of the Chinese. And he said it's unlikely. And they said, that's not good enough for us. Mm-hmm. So that was it. I mean, look, John Roberts on January 1 dropped his year-end report about the United States Supreme Court, the federal courts. Okay, his end of year, his annual, what do you call it? His state of the courts memo every January 1. And knowing that this case was coming up, he wrote at least 3 or 4 paragraphs about the threat of foreign adversaries controlling or on our social media and an attack on the judiciary. So we knew where his head was at.
I mean, he talked about misinformation on social media, what to me is content. That's what I'm saying. I just really think that I
got great news for you. I just heard that if you have a phone that has TikTok on it, you can sell it for $3,000 to $4,000 on eBay. That's how much TikTok loaded phones are going for right now. So if you have everybody out there, if you have an old phone in your drawer that has TikTok on it, you can sell it for a lot of money right now. But we'll see.
Yeah, and Americans are going, they're not giving it up. They're going, they're changing their VPNs and finding all sorts of ways to do it, which to me shows why this law was really short-sighted.
Ingenuity is another invention.
And you know what this Supreme Court opinion showed me? We're not ready for AI. The Supreme Court, when they said to the lawyer for the government, or TikTok, like, can't they just open source the algorithm for TikTok? I thought they have no idea about this technology stuff, which is
somebody
really
taught
scary.
him open source. The clerk taught him open source.
Oh my gosh. I was just like, it scares me how little they were like knowledgeable about algorithms, right? Or any of this, or data security even.
Well, this is what's going to happen. As we get even more sophisticated, they're going to be, unfortunately, at the forefront of decision making. And it doesn't help that John Roberts effectively took away the Chevron decision along with the others, which said that we used to defer to the expertise of people within agencies charged with regulating areas like AI, cryptocurrency, digital assets, nuclear power plants. And now he actually said in an order that we talked about over the summer, the Loper-Bright decision in overturning Chevron, John Roberts actually said, I think he wrote the decision. He actually said in the order, the majority said in the decision, it's not for us to defer to experts who know what they're talking about. I'm paraphrasing now. It's for judges to interpret the law. Good luck. People who couldn't pass biology in high school are now going to be deciding AI, sophisticated ethical and other security issues. But that is the world we know. It is for judges. He was always took such umbrage about it. But look, we could go on. We could make a marathon edition of the Unprecedented. Welcome back. Every week we come together, Dina Sayeghdal and me. We look at all things United States Supreme Court, inside the court, the hearings, the oral arguments, what cases they take, what cases they don't take. What's the relationship among the justices? Why does that matter? Who's in the majority? Who's in the concurrence? Who's in the dissent? What's going to happen with the Trump administration cases for this current term? And then we look at everything outside the United States Supreme Court, the corruption at the federal court system up to the United States Supreme Court and the ethical scandals swirling around them. So until my next reporting with Dina Sayeghdal, only here on the Legal AF and Unprecedented, I'm Michael Popak. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.